just wanted to make a record of the labor to this document. This item, the only item that actually admitted to justice. They're not aware of the existence of the document that certifies. It's never been the state's argument that it's not placed on any required notice that this was a software introduction, not a desk, it's a pure software introduction. And I thought that's how this was. We did not have a chance to discuss whether the certification is sufficient. And I'm concerned because on its face, all it says is that the person who reports to the records custodian that they're not being verified. It's stated under penalty of perjury. I don't know who this person is, but they haven't this call. Also, only author certifies it's a true and correct copy of who sheriff post investigation declined letter. By its face, this is not the investigation. This is the decline letter. And that's my concern. That's the concern I articulated to from the outset, is that this is a charging decision. And that's where I had concern. That was my entire argument why I didn't believe that it fell within those three. Understanding that the court's rulings that now given these additional piece of evidence, it's new, just happened. I think this changes the tenor. And again, I understand that the court is not inclined to exclude this item entirely, but I would ask that it be redacted to only contain the part that would be certifiable as the declined letter, the surface sheet, which contains their conclusions based upon whatever investigation was done, if any investigation was done. Their assertion of facts is unnecessary and it invades the province of the jury. Their conclusions of facts will require, if placed before the jury, I'll have to have.
You've already addressed this.
And I understand. I won't believe this. But that's my concern. And I think it would be an easy way to avoid prejudice to simply give them the certification and the front page letter. The import of it has already been addressed. The coded value has already been put before the jury. They already know that he was found. The charges were. I did not contest the contents of the letter at any point during any of these examinations. And I feel that based upon how the questioning was done, that door was not open. I relied during cross-examination when the court cautioned me that the question might open the door.
Open the door for in that moment. And the only reason that it wasn't is because I was telling counsel that that's where it would go if we continued that line of questioning. But certainly it left an impression on the jury, this discussion of an internal investigation, and it wasn't struck. But that's besides the point. And again, I've already indicated, Mr. Hunter, I understand the argument as it relates to the certification. The certification itself is not substantive evidence. It's the vehicle by which the substantive evidence here, proposed Exhibit A, is purported to be authenticated. And frankly, there's more than one way to skin a cat in the sense that there are other means by which this document can be authenticated, not just simply certification. And so we're not even crossed that bridge yet. So I understand you've been permitted to make your record. Anything else we need to address before we?
Judge, you mentioned states or Exhibit A. Can I trade it, or I have the new document actually with the certification on it. I guess I would retract the previous one for this one to be admitted, and I did mark it still as Defense Exhibit A so that the record is clear we're still talking about the same document.
No, it needs to be marked as Defense Exhibit B because the court has considered Defense Exhibit A. I'll consider Defense Exhibit A withdrawn then. Anything else?
Nothing further.
Mr. Najarian? Have a seat, please. The parties are present, jurors are now present and properly seated. Mr. Norris.
Thank you, Your Honor. Defense would recall Sheriff Robert Norris.
Sheriff Norris, you've been recalled as a witness. So I'm going to make you retake the oath. You just please here on seat. Make yourself comfortable. Mr. Hanners, redirect.
Thank you, Your Honor. Happening, Sheriff. Now, during cross-examination, the state asked some questions I want to clarify. Mr. Hunter asked you if swearing or curse words was against the law. Yes. And you had responded that it was not. But it is in fact a portion of the disturbing the peace statute, is it not?
Objection, Your Honor. You may approach.
Mr. Hanners.
Thank you, Your Honor. Sure. Could loud yelling, regardless of the words, could that be a violation of this statute for disturbing the peace?
Yes.
Screaming over each other.
Yes.
So, earlier we referenced that the temperature was rising in the auditorium, and there was a lot of shouting going on.
Yes.
Any bit of that could be considered disturbing the peace, could it not?
Yes.
Which would then grant you the authority.
Objection, leading.
What action can you take if someone disturbs the peace?
Objection is the form of the question and relevance.
Oh, you can answer.
So, I'd like to refer back to my previous testimony that it was the totality of all of the circumstances that were present during that period of time that made me fearful for everybody, but especially the disabled, especially the elderly.
Sheriff, I appreciate that. Just specifically, what action are you authorized to take if you witness disturbance of the peace?
You're authorized to make contact. You're authorized to seek cooperation. You're authorized to, if they fail to do that, if you want to seek prosecution, to give them a warning. And if they fail to do that, so you can ask them to leave, have them removed.
And Mr. Hunter also asked you about your role in the bomb threat issue. He specifically asked if you've been in contact with the Coeur d'Alene Police Department, who testified was responsible for that threat, correct?
Correct.
And were you in contact with anybody regarding that threat?
Yes, I was.
And who was that?
That was our on-duty watch commander, Ryan Odegaard. And,
No. Oh, I'm sorry.
and he had been in contact with their watch commander,
And,
the Coeur d'Alene Police Watch Commander.
and you said Deputy Odegaard, that would be Coogee County Sheriff.
Yeah, so Sergeant Ryan Odegaard is a Coogee County Sergeant for the Sheriff's Office.
Now, Sheriff, I'm approaching you with this been marked as Defendant's Exhibit B. Please have without showing the jury yet. Tell me if you recognize that document. Just that you recognize the number.
Yes, I do recognize this number.
Previously, the state had asked you questions regarding whether or not you handled the situation during the town hall meeting appropriately.
Objection, I did not ask that question.
Excuse me.
Previously, Mr. Hunter asked you about why you made the decisions that you made in the town hall.
Objection, I did not ask that question. Council can specify which actions.
I think it would be helpful to talk about what specific decisions we're talking about here.
You recall the questions that Mr. Hunter made in relation to your interactions with Ms. Moore.
Yes.
And you're aware that Sure. You said you didn't recognize that document.
Yes, I do.
Why do you recognize that document?
I recognize that document to be a independent investigation from the Attorney General's office and describing my actions taken on that particular day in February.
And to your understanding, that was a result of, that document is a result of an investigation into your actions, right?
Correct.
That's what moved you to admit to the meeting.
Address the objections previously on the record, and consider those objections still stand as they relate to the admission sought presently. Mr. Hunter?
They do object at this juncture to lack of foundation in the overall application thus far. I don't think we have that before. I think we have that established here.
All right, I'll take a look. Reviewing defendant's exhibit, proposed exhibit B appears to be certification. Form of a true or a copy of the investigation. Witness further testifies, recognizes the letter, recognizes its contents. B will be admitted.
And Sheriff, are you aware of the conclusions that were reached from that investigation?
Yes, I am.
And what was that conclusion?
I am aware that the Attorney General's office concluded that I acted within my responsibilities as sheriff, and that the actions I taken, that I took were reasonable and necessary.
And not criminal,
Not
correct?
criminal. Correct.
Nothing further.
Cross-examination.
So that matter, with regard to investigation that you did not directly have any involvement with, correct?
I did not have any direct involvement with it.
You were not interviewed?
It's not my investigation, correct?
You were the subject of it, weren't you?
Yes, I was.
You were never interviewed during that investigation, were you?
No, I wasn't.
There was never an internal investigation conducted by your office as to your use of force, was it?
No, we knew that there was.
No, it's just a yes or no. we're precious little time.
What was the question again?
Your office did not conduct an internal investigation into your use of force in this case, correct?
Correct.
And as the sheriff, you're aware of public commentary that was made about this investigation, about this incident, and its aftermath,
Well, I'm fully aware. I'm very much aware of that.
in which you agreed that it was represented that an internal investigation would be conducted.
That's correct.
Well, one minute, please.
Objection.
Would you like me to answer why?
Well, the objection will be overruled.
I think at this point, that's foregone.
Would you like me to answer why?
I think at this point, that's foregone. One last clarifying question. Your testimony on cross with regard to communications you had about this bomb threat, you understood that I was asking about any communications directly or indirectly to the Portland Police Department at that time. Did you not?
I interpreted it as directly.
And you never mentioned on cross this indication that a Sergeant Odegaard was involved, correct?
That's correct.
And read the record.
No, Your Honor.
Names, witness, excuse.
Yes, Your Honor.
Thank you, sir. Thank you, excuse.
Defense
Thank you, Your Honor. State Patrol Detective, or Chief Dan Hayes.
Yes, Your Honor.
Okay.
I did.
All right. We'll bring it again, please have a seat here,
Thank you, Your Honor.
please make yourself comfortable. And Mr. Baker, you may inquire.
Thank you.